Leading on from that, South Korea is set to fully enforce its Basic Act on AI on Thursday, becoming the world's first country to implement a comprehensive AI regulatory framework. As debate grows over whether the law will guide responsible innovation or weigh down a fast-moving industry, we're joined by Lee Hee-eun, Professor of Law at Handong International Law School. Professor Lee, it's good to see you.
Hey, good morning. It's good to be back on the program.
So, Professor, Korea is becoming the first country to fully enforce a comprehensive AI law. And from a legal perspective, is this a bold first mover advantage or a risky move given how fast AI technology is evolving?
I think it's kind of somewhere in between because what you're seeing here is basically the Korean government engaging in a regulatory sandbox approach. Basically, what that means is you put the law into place and then you have a transition period. And as you noted in your reporting, the government is going to really delay fining people and fining companies if they don't comply with the rules, because you need to have a transition in terms of this process by which the government will now impose these regulations. So the advantage here for the Korean government is, they want to be a first mover in terms of being able to regulate and then, basically approaching this issue in a very sensitive way while trying to also promote the development of technology. And that's a tricky sort of balance to make between, regulation and protection, but also allowing enough freedom for the companies to be able to develop this technology going forward. The big risk really is this. If the regulations are a bit too burdensome, then the question is, can the Korean government then adjust these regulations so that these AI companies are not going to be hindered with respect to the development because they're competing with other players globally, right? Like OpenAI, like other companies beyond the domestic market. And so as a result, I think this approach tries to straddle both the regulation, but also the development of this technology going forward.
Thank you, Professor. And one of the most controversial parts of the law is the concept of high-impact AI, which triggers direct legal obligations. Do you think the standard is legally clear enough, or does this risk creating uncertainty and disputes down the line due to its ambiguity?
Yeah, inevitably, whenever you have regulation, it's going to have to be clarified later. And usually, what that means is either in practice, but typically through litigation in the courts, whenever these issues then arise, the courts will then have to give some definition to these terms. However, when it comes to these regulations, because you have a year to sort of play this out in the market, then I think these companies and the regulators will then have more time, hopefully, to address these specific concerns. But because this is such a fast-paced development of technology, you're going to have situations where the regulations don't necessarily address these issues in a clear way. And so as a result, when it comes to this high touch or this high impact AI that's going to have effects on individuals' lives, a year is probably not enough time to resolve all these issues. So inevitably, there's going to be hiccups, there's going to be bumps along the road, and there's going to be eventually be court litigation probably on these kinds of questions. So as a result, I think when it comes to high impact, particularly as it relates to individuals and their rights, I think what you're going to see is probably more development of these issues going forward, and then the courts getting involved to resolve some of these ambiguities.
So AI startups are arguing that the real fear isn't fines, but being labeled as illegal due to procedural violations. Now, how serious is this concern under administrative law, and what safeguards do you think there should be in place to prevent over-deterrence of innovation?
Right. I think this is really the crux of the problem because the government is regulating this industry now, and properly so, because people's lives can be really impacted and harmed by the use of AI. So for instance, right, if you're going through a job application and the company uses AI to, reject you, or a loan application, for instance, or college admission even, if colleges uses AI to determine who's fit to enter a university, these kinds of issues obviously have a lot of impact in society. But on the flip side, right, the regulators have fines, and not just fines, which is not necessarily so overwhelming. These penalties financially are not that significant in comparison to some of these companies. However, there is a damaging element if they're seen to be not complying with the regulations, because in the future, if you're labeled to be undertaking illegal activity, the government may sort of prevent you from receiving more research and development funds from the government. And so I think that becomes probably a big issue for a lot of these tech firms, especially the smaller ones that really are dependent on this technology to be able to access government money. So I think in this case, there is the danger for some of these companies to be able to be labeled as engaging in illegal activity for the purposes of receiving government funding later.
Now, there's also some growing concern that domestic firms will face strict enforcement while foreign AI big tech firms remain effectively out of reach. So do you think this new law has the legal tools to address this imbalance, or is reverse discrimination inevitable?
Yeah, that's a great question because this really goes to the extraterritorial application of this rule. What that means is this is a Korean law, but the question is what reach will this have on some of the big major global tech companies like Meta, like Google, for instance, and OpenAI, who are obviously all of us know these companies who are engaging in development of AI, and people are using them here in Korea. And so the question really is, can the Korean law reach these companies? Because basically the theory or the application of the law here in Korea is if you're serving the Korean market, you have to play by Korean rules. And so in this case, these foreign companies like Google will have to then make adjustments and have a presence here so that if, and the law requires this, they have to have a domestic representative so that in the event that they are found to be in violation of the rules, that their local representative will be held liable and can address these concerns for the Korean regulators. So in this case, I think time will tell whether or not these big companies will have to make significant adjustments, certainly within the Korean market, but whether or not we'll have an application broadly, I think it remains to be seen. But I think Korea being a first mover, I think is shaping the policy now going forward for a lot of countries who will now, I think, benchmark Korea's rules and see how they play out for their own regulatory systems.
Okay, thank you for joining us this morning, Professor. We appreciate your insight as always.
No, thanks for having me.